Once you have your agreement finalized in a mediation, then the next step is to have that documented in a final decree of divorce. Now, your mediated settlement agreement may be a few pages, maybe 10 pages maximum, but your decree is going to be like 50 pages. It's a long document. And the reason for that is that a lot of detail is included in your final decree to make it enforceable so that you get what you're entitled to, your ex-spouse gets what they're entitled to, and if you need to, you can go back to court and say, this is what they owe me, this is what they were supposed to do, and they didn't do it, and please make them do it. So there has to be a lot of legal language, a lot of detail in your final decree. So it's a pretty long document. Once that decree is prepared, everybody's reviewed it, signed off on it, then you have to get the judge to sign it. And there's a few different ways that this happens depending on the court that you're in. So the typical way is that you would go into court and in person and ask the judge to sign your decree. There's a process where your lawyer will ask you questions to do what we call prove up the decree. Essentially, you're just asking questions that have legal requirements that the judge needs to hear to make sure that they have jurisdiction, to make sure that that the proper things that they want to see included in your order, especially with regard to kids, are included. And then it's just a process where they sign off on the decree.